Welcome, everybody. Today is another episode of Garris Insights. Today we have our partner, John Levnick, who specializes, amongst other things, he's the business guy who's got the Juris Doctors, as he says, very similar to me. What does that mean? It means that he knows the law very well, and yet at the same time can navigate the business needs of our clients pretty darn well. And I've seen him do that in real time. It's pretty amazing. So today, what we want to talk about is kind of cyber world, cybersecurity issues. We know it's a hot button issue. Everyone's talking about it. But John in particular has a unique perspective, being, again, on the business side, understanding how this works, talking to his clients, drafting agreements around it as well, and ultimately talking about the legal requirements and around it. So, John, any initial comments that you have that you want to make?
Well, thanks for having me, Ray. As you know, I always enjoy talking about these subjects, and I think it's a really important message to get out to the Garris Horn world that is watching. So thanks for the opportunity.
Great, very good. Well, glad to have you, and I think it really is a great topic, especially the way we're going to talk about it, because I see where we're going on this. Now, I want to ask a question that's probably first asked. Anyone who's listening is probably going to want to know and would love to ask you. We're seeing a lot of things in the media in regards to cybersecurity breaches. And I think it's the holding hostage for the information, however it works, right? But the question is, how is it happening? What are you seeing?
What I'm seeing is a lot of organizations that aren't quite sure of where they need to be and what they need to do. We all read the Wall Street Journal, New York Times, LA Times, and pick up and see on the cover that, big lender suffered data breach. What does that mean? Big lender was, operationally taken over or locked out of their systems. What does that mean? Right. So a lot of what we're talking about here today, as you mentioned, while the legal and regulatory world drives the requirements, at the end of the day, so much of the cybersecurity concerns for the businesses are around continuation of services and the ability to withstand a breach and ensure that in spite of the breach, that not only do they protect their consumer data, but they also ensure that their core operating systems are up and running and available to their employees so they can continue on conducting business. I think a lot of CEOs and CFOs fear breach for the sheer point that any business interruption, if they can't access their core critical systems for a week, that's a significant amount of revenue. That's a significant loss. That's a significant number of clients who are materially upset and may go elsewhere. And it reputationally is hard to recover from. So sure, there are legal concerns, there are regulatory concerns, but at the end of the day, continuing services, continuing access to your core systems, that's what these hackers are looking to do. You hear about phishing, you hear about how they might be entering, but what they're looking to accomplish is they're looking to disrupt companies. They're looking to hold companies hostage, to pay a large amount of money to get access back to their own system so they can continue on conducting business. And the likelihood of a business paying a hacker isn't driven by the fear of the legal regulatory implications. It's driven by the fact of, all right, it's going to cost me $1 million to get access to my system again because I'm about to lose $10 million in lost opportunity costs. So it's a cost benefit analysis that these hackers have, forced these business people into to make determinations and on whether or not to pay to ensure that they can continue operating in the normal ordinary course business.
Yeah. So I suspect that um, what we're seeing in the way that and the way it's being approached and it's being attacked, I suppose, is going to be both from either some kind. You still have to do penetration and be concerned about that, and it's as simple as somebody clicking and saying, "Oh, it must be my IT department. I'll just click here and give them my password." And so I
Right.
think there's quite an array of how the exposure is there, and
Mhm.
and though I suppose you know while we have to cover for that array, it's not like you have to do 1,000 things to get that covered. You might have to do 10 or 5 or something is my
Right.
guess. But now that we see this, and what we also have seen in the media as a result, is we're seeing more traction by regulators to get in our business, if you will, about cybersecurity, and particularly the states. That's what I'm seeing. What are your thoughts on that?
Well, somebody has to hold these organizations accountable for ensuring that they've got the minimum standards to protect consumer data. In the financial services industry, which we make our living and our clients make their living, we and they are in our ordinary course business obligated to hold the crown jewels, which is consumer non-public personal information, consumer financial information. Um, you know, that obligates these organizations to ensure that they have the requisite controls to responsibly, uh, show somebody, and at this point it's a regulator, that they understand what their obligations are, how they fulfill these obligations, at least to a minimum level of competence, and have the minimum controls in place. And I think that's what these regulators are starting to look at through future enforcement actions or enforcement actions, is that they're not looking for financial institutions to have the most elite of protection systems, but they're looking to see if these organizations understand what their obligations are, understand their IT infrastructure, where it is, where the data is at any given point, and can assure the regulator that based upon an understanding of their infrastructure and a knowledge of their obligations, how they fulfill certain rudimentary or fundamental protection, cybersecurity, and data privacy protection controls. And it's a lot of scary terminology for a business, but it comes down to a simple fact that there are fundamental pillars. The baseline regulatory obligation, which the regulators are looking at now, is the amendments to Graham-Leach-Bliley Act under the enhanced safeguards rule. The safeguards rule is not overwhelmingly hard to meet, and if a lender can't understand what their obligations are in light of the Safeguards Act, and then show a responsible third party, such as a regulator, how they meet those obligations, it's incumbent upon the regulator to ensure that the lender does understand what those are and does meet those obligations. And unfortunately, in our industry, sometimes financial institutions don't act in a certain way until they have to, or until it's too late. So, in the absence of becoming aware of what your obligations are through a negative action, such as a breach or a hack, you know, the regulatory enforcement is forcing financial institutions to really assess, all right, who am I? What are my obligations? And how do I fulfill those obligations? And then, most importantly, how do I represent in clear, unequivocal documentation how I fulfill these obligations so a third party can see, based on my policies, procedures, for example, that I understand those elements, who I
And
am,
I
what my
yeah.
obligations are, and how I fulfill them.
And what I'm seeing is at least what I've heard is that it's not just enforcement actions, it's just standard routine examinations. So even in standard state routine examinations that we have, they're increasing their interest and questions in that regard. And I submit, you bring up a good point. I submit that a lot of companies would have concerns because the scope of the question is something like, wait, what's the answer here? Now, in light of also that some companies are a little bit lighter than they used to be insofar as staffing, you might not. It's hard to get a handle on what the answers are. And I'll tell you even this much: it's it's not even knowing what to ask as to what the answer is supposed to be. What are they asking for here? Is this the fact that we're using McAfee? Is that the answer here, or are they asking for penetration testing? We don't really know the scope of the question. So if we have McAfee, are we good or not? Right? These are the things that I suppose between the questions and the interest by states, and then looking back at it. I'm not mocking companies. It's just these are just like you said. They're using terms and expectations where look, we package and make loans and we do safeguard stuff, but now they're really asking very precise questions, I suppose, and so that could be more of a challenge, right? That's what we're seeing
Yeah,
anyway.
it's a challenge, and where it starts, Ray, with anything else, it starts with education. It starts with knowing, once again, who you are. I'm a federally chartered bank. I'm a state licensed MLO in these states. The difference between the two are certain regulatory obligations, boxes that they have to check off and show that they understand what their obligations are, and specifically how they connect what their obligations are to the regulatory obligations.
Yeah. So and I think that becomes now the question, right? So, uh, what what are they asking for, and more importantly, how do I understand what I'm supposed to have in place? And I know it's a trick question. You just mentioned it's like, well, if you're a bank, you need this, and if you're a small independent mortgage bank, you would need that. So they're not necessarily the same thing. But what should I be looking for insofar as solutions or technology or and not? I don't want to overbuy. Right? There's no need to overbuy, and I certainly don't want to,
That's
under support or
that's
underbuy
great.
either. Yeah. So what
Absolutely.
thoughts? Yeah.
Well, this is going to sound like a commercial, but here's a typical scenario for which I'm brought in. It's you've got a large financial institution or a growing financial institution that that understands that they are going to be held accountable for cybersecurity at some point, right? The state regulatory enforcement, the pending enforcement action, threat of enforcement actions hanging over their head is a good example. And you know where we are brought in is that we sit down at the table with the client and we go through the exercise I just highlighted earlier. All right, who are you? What is your regulatory footprint, right? Who are the regulatory authorities that you're subject to? And as a result, what are the express statutory regulatory obligations that you have to fulfill? And not every institution is different, but there are buckets of different institutions. And the key is to define the requirements for the organization. Then you work into their infrastructure as it stands today. Okay, what does your technology stack look like? Are you entirely on a cloud service provider such as AWS or Azure or Google? Or do you have servers on premise entirely? Or do you have an Exchange server on premise and then you use AWS or Azure for holding all of your files and your virtual desktop experience? So you kind of uncover who they are, how their IT stack stands today. And then what you have to do is, based on their IT infrastructure, you assess where their controls are. You threw out some buzzwords earlier. Do you have the requisite firewalls, right? Do you have multi-factor authentication? Do you have the next step? Do you have a single sign-on capability, like a federated identity control process, where a remote employee gets on their terminal at home and with one password can access the entire corporate network as it applies to them and have access to the external applications, right, through a controlled desktop experience. These are the types of questions that have to be answered to say, all right, well, if this is how you do it, you need this, you need a firewall, right? You need sign-on controls, you need secure access to the corporate network, you need for each employee, right? And you get deeper down the rabbit hole. Do those employees have their own endpoints, their own devices, or does the company issue laptops to the company? Can they control the endpoint device? What does the corporate network consist of? It sits on AWS. That's great. You've got a VPN into it. That's a secure access point. But what's the back end of it look like? Are you protecting the back end infrastructure? So these are the types of Q&As that will allow for then a tailored assessment to come in and say, okay, you are subject to these rules. Here's your IT stack. Now, here's the delta. Here are the areas that you are sufficient. Here are the areas that you're deficient. And based on these deficiencies, here are the potential requisite controls that you need to fulfill. And what that does is it gives a CEO, a CFO, even a CIO, an understanding of, all right, this representative cybersecurity model applies to me individually. That I know now I need to go out and obtain these services. And these services are absolutely required for what my express obligations are. Nothing more, nothing less. The big fear here and stories that I hear of are CEOs or CFOs or CIOs going out and buying services, buying access to technology, and it's overkill. They're buying a Lamborghini when they need a four-door sedan, but they don't realize they need the four-door sedan because they presume that the Lamborghini's exactly everything they need in a single box, right? Where, it's not a one-size-fits-all approach, and they need to understand and account for who they are. And there's really, really smart ways about going about this, right? There's the legal and regulatory connecting of the dots, but believe it or not, legal and regulatory can be a springboard to ensuring adequate IT spend, that someone's not overspending, that they identify areas they might be overspending. And I've even had a client say, all right, John, we hate bringing lawyers in. Lawyers are expensive, the whole rigmarole. But at the end of the day, what we've paid, for lawyers to come and assess is covered under the savings that we've realized as the result of this exercise by bringing you guys in. And it's a really, as a compliance lawyer and compliance professional, always being a cost center, always hearing that,
Oh yeah.
we're a cost center, not a revenue center, right? It's really refreshing to be able to help people from a cybersecurity perspective, not only understand, but fulfill their obligations, but actually help them better understand what their obligations are so they can reduce unnecessary spend and actually create savings as a result.
Well, yeah, and I can appreciate that. I think that's really the key thing is was we talked about we don't know what we don't know. Often at the leadership level at these financial institutions, particularly independent mortgage banks, that's how they operate, and nothing wrong with that. I think it's how it works, and they want to be smart on their spend. We
Mhm.
don't go to your point. I think in some cases, again, nothing. Banks are great, but they get value on showing off what they spend more so than independent mortgage bankers. So mortgage bankers are more practical about what does it really do, because I really have to make sure we're covered and to the right degree and not unnecessarily more. So I can appreciate that. So it's crazy. So well, thanks for that. The other thing, and we'll probably want to talk about this in a future podcast, but it kind of is related, and that is the notification requirements. Right, those are changing now. There's thresholds, as you mentioned, the gram leach bilease, and particularly the regulations the for safeguarding has changed, particularly notification requirements, and I think HUD has done something as well. So the other end of this is if you don't do this, you have, which even if you do everything correctly, we can't say everything's perfect, stuff's going to happen, but then you have notification, other requirements. So this space, there's a lot to talk about in here. Now, ultimately, if you get something right and you deploy it, I don't care how much you spend. If you deploy the right stuff in place, cheap or not, good or inexpensive, not doesn't matter. But you get it right, we don't have to worry about notification. But
Yep.
it's good to know about how that's changing as well, because they're getting us on that end as well, and so that's driving, if you will, the notification, the public, I won't say public shame, but the public knowledge of these issues is starting to create also interest. Not just the examiner squeezing us on this side, what are you doing, but the idea that we have to go public. So right now we're in the center of it, and I can appreciate that. Is there anything else you want to bring up and share with our
Well,
viewers?
you mentioned notification, right? And it goes to the education of the client and allowing them to understand who they are. And I always start with the multi-state licensed mortgage banker, right? That seems to be the organization I always refer to. But there's a step before that, right? And knowing who you are. The notification, and this is in the past year or so. The threshold question is: are you a public company or not? Right?
Hmm.
That is who you are, because to your point, that's a determination of notification obligations. So, for example, if you're a public company, the SEC has put out obligations stating that if you are a public company, you are, a victim or subject to a breach, right? And these are all loaded terms, so it depends,
Of
case
course.
sensitive, what these terms mean. But as a public company, you have now an obligation to notify the SEC on a certain timeline. That means that you've got shareholders who need to know that there's a material risk for a company they may hold equity in. And beyond the SEC, there are other state obligations, right? Even on the state licensing, if you suffer, I guess at the federal level, you suffer a breach of records, right? It depends on, well, how many records did a person that access to your system see, right? So there are thresholds. Well, if they saw 3 or 4, that might not trigger a notification, but if they saw 500 or more, that'll trigger an obligation to a separate regulatory body. So what organizations need to do, and beyond the traditional policies and procedures, right? Here's our information security policy, here's our data security policy, and the fundamental documents that detail how they have their controls. The new obligations are notification playbooks, right? What do we do in the event of this happening? If we're breached, an organization needs to have a playbook, right? All right, what's step one? What do? We assess the depth of the infiltration. We remediate the entry point and try to eviscerate the individual's access from within the system, right? And then it creates a series of obligations, again, depending on who they are, public company, state licensed in New York, Washington, California, Texas, you know, all these states also have certain notification obligations, and it needs to be documented, right? You always hear the stories about pilots, right? And pilots are successful, and how CEOs need to follow pilots because there's checklists, right? You got to go down each and every item of the checklist. So these organizations need playbooks to say, this event happened, let's pull out the playbook, then we know exactly, in the midst of all this chaos, what we have to do, who needs to be involved, what actions have to be undertaken, and then most importantly, who needs to be made aware of this.
Yeah.
Specifically, you don't want to over disclose, right? I mean, over disclosure is never wrong, but you don't want to kick a sleeping dog if you don't need to. But who absolutely needs to be notified, and by when, and at what point? Because not only are they notification obligations, they're timeline driven, and if you don't notify within a certain time frame, then you are deemed to be insufficient and can be found in violation of a certain regulatory obligation. So notifications are very tricky, and there's a lot of typical lawyers. It depends on how.
It depends,
But
exactly. Well,
the
and
question is,
I will tell you that again, going to your point, is what's a breach, right? So how did or knowing about the breach? What do you mean know about the breach? And that is now shifting, where it could be we suspected but we weren't sure. Now we're sure. Now it's like, well, even if you. So I'm not going to. I don't know the answers for every state, every jurisdiction, but they're starting to focus on the obligation associated with there's a breach, and quote your knowledge of it, to what degree you had knowledge, and that's the trigger versus we had to confirm. They're not letting people, I want to say we're playing games, but they're tightening up. If I understand correctly, they're tightening up even when there's a breach, and the time starts from there, and what that knowledge
yep,
of breach means, right? So we're even seeing that kind of tightening up. So again, we're getting, I don't say we're being squeezed, but I think the requirements are coming from different angles, to the point that we kind of have to have a good 45-second speech on what you do for cybersecurity in today's environment, not 10 years ago, not even 5 years ago, not even 3 years ago, but in today's world. What is your 45-second speech? And that starts with knowing what you're supposed to know enough, and then
mm-hmm.
having a response to how you're addressing those needs, so you can address to other people. And then going to your point, when you have an emergency response, knowing when we have an emergency to begin with and how we respond accordingly. I think it's those elements it's all kind of pushing that we can no longer kick the can down about investing and understanding what our cybersecurity obligations are at any level of a company. Is that a fair statement?
Absolutely, absolutely. When you were talking about that, what jumped to mind is, if you have a security event, you don't have the time to put out an RFP for a forensic services provider to assess who is best qualified, then hire them and bring the guy, sign a contract to bring them on, right? You need to have that third party relationship at ready to go, and with a push of a button, set them into motion. So you're right. It's checklist, it's knowledge, but it's an array of subsequent elements that need to be standing ready and willing to act in a very timely manner. So it is complicated, but I think at the end of the day, knowledge sheds the light, is the best solution here, and getting understanding what these obligations are, and having the checklist ready to go.
Yeah. Well, very good. Thanks, John, for your time on that. Any last comments, questions, or statements that you want to make, and direction you can provide us? Sage advice from John.
Yeah, I mean the best place to start, I think, the questions I get are, One would be a general counsel calls and says, "Hey, I can't sleep at night because I'm nervous about this." Right? As far as a public organization goes, who's responsible for cybersecurity? You've got to have somebody accountable. Most organizations rely upon a chief information officer, chief technology officer, the people that build the tech, to also ensure that there's self-imposing obligations on themselves, right? To not only build it, but to monitor themselves, and then to assess the sufficiency of what they've built. Those types of models don't work in today's world. There needs to be a real segregation of function within organizations. And legal and risk seems to be migrating towards tech and IT more and more, to where risk governance now needs to be the entity responsible for ensuring all these controls are in place, and even holding their internal responsible parties accountable on an evolving basis by conducting internal audits periodically. Right? You don't put the person that's in charge of building also in charge of assessing the sufficiency of the build. Right? It's illogical, and you see a lot of CIOs and CTOs being very defensive about somebody looking at what they've built because they're afraid of somebody throwing stones at what they've built and bring into question potential insufficiencies, to where they get all self-conscious and say, I didn't, why didn't you do your job? Well, I did do my job, right? So there's got to be a culture of security. There's got to be an infrastructure set in place that's healthy for an organization to operate, right? For people to work in conjunction to ensure that an organization knows what their obligations are and are ready, can not only prevent rudimentary, infiltrations, but can act when necessary and don't have any internal roadblocks. And so many of the problems I see from organizations is that they've got their own internal roadblocks that they've got to work through. So, it's time now, the first step, the first, podcast here, right? Step one, right? Who are you? What are your obligations are? And do you have a playbook? And are you ready to act in the worst case scenario, right? We'll talk later date, Ray, about, what happens when a regulator comes knocking, or what happens, sure. In the event, what's the legal liability, or what's the regulatory liability? Is my license at risk here? We'll talk about that later. But I think for a first, step here is that an organization needs to look internally, build the appropriate controls, and seek guidance from somebody that can assist them in getting the fundamental controls in place and educating them on what those controls are and how they best need to fulfill them. Then you can go down the road on supplemental, purchases of services that are nice refinements and nice to haves. But start today on what do I need to have, and what I need to have is driven by who I am. And if you could solve for those first 2 points, you're way ahead of the industry.
I appreciate that. I think, really the key is if you don't know and don't have the ability to understand it internally, which is often the case, and that's okay, it sounds like it's a good investment to find somebody professional who can at least help you guide through that. Could be a lawyer, could be otherwise, but someone knowledgeable saying, let's exactly what you said, the framework of, okay, what are you? Where's your technology, cloud-based or not, right? Someone to cause you to have those questions, but at least they know what to do with it versus, many do not, and who lead these companies. So, well, very good. Thanks for your time, John. And I think we should probably have more of these conversations and find out what happens when people knock on the door. What is a breach? There's so much we have to cover here because I think it's timely, and I think, again, our listeners deserve to hear what you have to say. So thanks, John, for your time, and hope to do this again soon.
Thanks, Ray. It's always a pleasure.
Right. Thank you, John. Thank you, everyone, for listening, and stay tuned for future episodes of Garris Horn Insights.